Welcome to Talking Legal episodes, proudly presented by Baker White Lawyers. I'm Prabin, your trusted marketing advisor. I help entrepreneurs and enterprises to build a digital brand and monetize it. Today's episodes, I have got Amy Chesnutt, who is a senior associate of Matilda Family Law, which is a proud division of Baker White firm. Great to have you today, Amy.
It's good to be here again, Prabin.
That's great. Last episode, a little bit framing up, we talked about parenting orders, during COVID, and get some great feedback from our viewers. And obviously, this time we want to talk a little bit about property orders, if that's okay, because interesting time, with COVID. So if that's okay, we can a little bit deeper on the property order matter.
That sounds fantastic, Prabin. We've had a lot of inquiries in the last few weeks and months about parties wanting to finalise property matters or, in some cases, revisit their financial matters. So it's really important that we flesh that out again and discuss further about what this all means in the current climate.
Beautiful. Yep. So let's start with very basic, Amy, if that's okay. So what is, those viewers who are watching this right now from a number of our media, Facebook and Instagram and YouTube. So they might be thinking, what is property law? So what is the basic summary, please?
So property orders are orders that are made under the Family Law Act 1975 regarding parties' financial affairs. So it's the division of matrimonial de facto property, how that works in practice for parties, what that agreement is or what the directions of the court are in that regard. And it essentially finalises all financial matters between parties who have separated, and it severs those financial ties in most situations. So when these orders are made and these orders are made final, that is it for parties. They can move on. Their financial affairs are no longer tied with the ex-spouse or ex-partner, and it is binding and simply can't be revisited except in very limited circumstances.
Right. So that's pretty interesting. You say that about when is it appropriate to set aside the order, Amy? Then.
Okay. So as I said, property orders are when they are final orders. That means exactly that they are final. There are limited circumstances where it is appropriate, or you could apply to the court to set aside those orders. There are specific provisions in the Family Law Act that apply. For married couples, it's Section 79, capital A. For de facto partners, it is Section 90, capital SN. Now, you'll hear solicitors sort of call it the colloquial, it's a 79A application. What that section and the de facto section says is it relates to the very limited scope that the court has to revisit final property orders, and there are specific grounds that you must fit within one of those categories in order for the court to entertain reopening your matter. For the court to entertain setting aside your orders or varying those orders or substituting those orders with new orders that may be applicable in your situation.
Right. So, obviously you mentioned it's very technical for sure. Those viewers who are watching this, Section 79 and 90 SN. So we'll get onto it. But just on that note, if you guys are watching this right now, different channels, I'm with Amy Chesnutt, who is our senior associate, who help in family law matters. So let's and we're talking about property orders today. If you're just watching this now, just give a thumbs up, comments, or share this post. Now let's go a little bit deeper, Amy, if that's okay. Well, what is then? Explain the grounds. We're curious to know what is the ground of 79A and 90. Was that 90? What was that? 90
SN.
SN. Okay. What is 79A and 90 SN, please?
So the one that generally is used by parties is the consent grounds. So there is an ability for the court to revisit property orders if it's appropriate, if the parties to those orders consent to that occurring. That's the one that we regularly see in practice, because often when people make final orders and they agree to it, circumstances have changed since the making of those orders, and they both are on the same page with, hey, this is no longer working for us, or we need to tweak things. So you can submit to the court a 79A or a 90SN application by consent. That's the first one. The other grounds that are set out in the relevant sections are where there is no agreement between the parties, and one of the parties is seeking that the court reopen and look again at the financial matters between these parties, and set aside potentially the final orders that have been made. Those grounds are very specific. The first and most obvious one that we do encounter is it's called a miscarriage of justice, because arising because of fraud, duress, or suppression of evidence, or someone giving false evidence in the original proceedings. The most common scenario that arises there is if a party has failed to provide what we in legal terms call full and frank financial disclosure, but in lay people's terms it means you haven't told the full story of what your financial situation is. The example I give to clients is somebody has squirreled away $1 million in a bank account but not told the other party, and the other party has settled because they assume the pool is X, but it turns out that it is Y. That may be a grounds to apply to the court for the orders to be revisited. Another scenario that we encounter is if there have been circumstances that have arisen since the orders were made that make it impracticable to carry out the order, i.e. things have changed since the orders have been made. We can't do this because of whatever reason, therefore this order just simply cannot be put into practice, and the intention has changed, the landscape has changed. Another ground that I don't often see but does come up is if somebody has just simply not complied with the order, and as a result the other party is prejudiced. We call it a party has defaulted on their obligation, and in the circumstances arising because of that, it's just and equitable or fair for the order to be varied or otherwise set aside. There are two other grounds.
So what are they? Yeah, so you talked about the consent, miscarriage of justice, and giving a false information. So what is the other two, Amy, please?
The other two grounds are if there is hardship, but it's very specifically worded in the relevant sections, and it is only relevant where the exceptional circumstances have arisen since the order was made relating to the children of that relationship, or if an applicant has care of the children. And the last ground that can be utilised to apply to the court to set aside these orders is if there's been a proceeds of crime order that's been made. That very rarely arises in our day-to-day family law practice here, because of the implications when there is a proceeds of crime order, and that generally suggests that there's been some, if I can call it, funny business going on by one of the parties.
Right. It sounds, there's obviously, it's a very much technical for those viewers who are watching this, and it's important to have the legal advice, I would imagine, isn't it? Because people have spent all these years in building their property or wealth, and so it is. What's your thought on that? Do you agree that they have to? It is important to have to get the proper legal advice, Amy?
Look, Pravin, what I often find is people underestimate when the court can revisit an order. It isn't as simple, unfortunately, as I don't like this order. I would like to change it because it just doesn't quite work for me. You have to meet one of the grounds in Section 79A or Section 90SN, whichever is applicable in your particular circumstances, for the court to have the ability to reopen your matter and potentially set it aside. for that reason, it's absolutely imperative, in my view, that you obtain legal advice from a family lawyer as to whether or not the application has any prospects of success. These applications are the exception, they are not the rule. We don't often encounter them in practice because we as practitioners understand how difficult it is to succeed in these applications. My very strong advice to everyone who is considering revisiting any orders is to seek that legal advice early on to determine whether there is any merit in bringing the application and whether you can meet any of the criteria set out in the relevant sections.
That's a great point, Amy. Yes, please.
So sorry, Pravin, I was just going to say that if you bring an application that is doomed to fail, then there are complications that may flow from that and cost orders that could flow. Again, highlighting how important it is to involve your legal practitioner and your trusted legal advisor from the get-go before you bring an application.
Absolutely. No, that's a great point. Getting that right people or getting that trusted people on board and having that trust call or having that conversation start with the legal advisor, very critical. That's for sure. Now, obviously, those viewers who are watching this and they might have issues in property or parenting order, what would be the best contact for you, Amy? So
there are a couple of options available for clients if they are seeking legal advice about family law matters. I'm available on email. My email is amy, A-M-Y, @matthewlove.com.au. The other option is by contacting us on our telephone number. Our telephone number in Brisbane, the local number is 0733902344. We also have a free number, which I think is popping up on the screen now.
1300, yes.
1300@legal. So if you are encountering any issues or potentially want to look at maybe revisiting your orders, by all means, do give us a call or send through an email, and one of our practitioners, myself, we can assist, definitely.
Beautiful. Thank you so much, Amy, for your time. I hope that's been very clear for our viewers right now who are watching this, because last time you discussed about parenting orders and property goes hand in hand. It's very important. Now, any other final things you want to share or you want to add before we wrap up for today, Amy?
Look, again, Pravin, it all comes back down to when you want to finalise matters between an ex-partner or an ex-spouse, obtaining good, clear, concise, family law relevant legal advice is absolutely imperative. And this is what we do every day, so we can help make the process much easier for you and navigate through these potentially rough waters with you to get the best result possible.
Beautiful. Thank you so much once again, Amy. I hope you guys enjoy the talk with Amy. And obviously, if you have any burning questions or if you have any particular matter you want to discuss with Amy or with our senior associates, feel free to just email them. And and we are there. We will definitely take that on the next episodes, or we'll try to resolve that. So thank you once again, guys. I will see you on the next Thursday. Bye for now. Bye, Amy.
Thank you, Pravin. Bye.
Yes.